Lydia Olaiwola and the United Foods Industries Limited. My lord, I don't know whether parties are online.
Okay, appearances. Appearances.
May the call be please. Kingsley Kenechukwu with CE Ezechi, Grey Law Partners. CE Ezechi for the claimants.
Okay.
Respectfully, AI Muda Arai. Muda Arai is MUDA-AIRAHI for the defendant, my lord.
Okay. So this is the judgment of the court between Ms. Adenike Lydia Olayiwola and the United Food Industries Ltd. By general form of complaints, statement of claim and other accompanying processes dated and filed on the 6th day of June 2022, the claimant instituted this suit against the defendant seeking the reliefs as follows. One, an order declaring the action of the defendant to terminate the claimant's employment on the 11th day of April 2020 existence, and that the claimant is entitled to a 1 month in lieu of notice, salary, and other benefits from the respondent. Two, an order declaring that the dismissal upon the recommendation of the panel is void due to lack of fair hearing. Three, an order directing the respondent to pay the claimant the sum of 20 million naira as general damages and trauma. And four, an order of this court directing the respondent to pay the sum of 200 million naira only to the claimant for specific damage. The claimant's case is that she was initially employed by the defendant on 7th day of March 2016 as an apprentice in bracket office assistant on a contract basis, and was later offered permanent employment as a HR assistant effective 2nd day of January 2022. In that role, she worked directly under the defendant's group HR and external relations director, Chief Kola Hassan, whom she alleges subjected her to persistent verbal abuse and intimidation. On the 4th of April 2022, the claimant received an invitation to appear before a 7-man fact-finding committee investigating an anonymous defamatory letter allegedly sent to Chief Kola Hassan. Following the panel's hearing on the 7th of April 2022, which the claimant alleges was conducted without affording her a fair hearing, she was issued a query on the 8th of April 2022, accusing her of being the author of the letter. She responded to the query on the same day. Thereafter, the defendant terminated the claimant's employment by letter dated 11th of April 2022. The claimant further alleges that following her dismissal, the Chief Kola Hassan threatened to use its influence and connections to humiliate and intimidate her. She claims she subsequently received threatening phone calls from unknown persons and was subjected to police harassment, causing her psychological trauma, pain, and emotional distress. Grieved by what she considered to be the wrong termination of employment and the alleged violation of a fundamental rights, the claimant instructed her of employment benefit under the defendant's employee handbook. The trial commenced on the 17th day of June 2025 with the examination in chief of the claimant, Ms. Adenike Lydia, marked and admitted by the court and accordingly marked as follows. One, exhibit C1 to C9. The details of the exhibit are all in the body of the judgment. I'll go now to the defendant's case. The defendant is a registered Nigerian company involved in food production with its witness being the HR administrative manager at its Ota branch. The witness claims that many of the claimant's allegations are false and misleading. Specifically, the witness stated that the claimant was one-year contract in March, confirmation on the 24th of July 2020, following a fresh offer in December 2019. The witness confirms that the claimant's termination on the 11th of April 2022 was lawful, with full benefits paid, including 1 month's salary in lieu of notice. However, The claimant failed to complete the required final clearance as mandated by the employee handbook. The defendant witness denies that the claimant was intimidated or harassed by a certain Chief K. Hassan, asserting that the claimant never filed any complaint. The witness attests that the termination process was fair, impartial, and guided by natural justice. A fact-finding committee was set up to investigate the defamatory letter against the Chief H. Hassan, K. Hassan, and the committee was independent and impartial. After careful review, the committee implicated the claimant, leading to a termination. The defendant witness denies any police instigation by the defendant, affirming that Chief Hassan acted independently. Ultimately, the witness claims that the suit is frivolous, an abuse of process, and should be dismissed with cause. The following documents were also admitted and marked Exhibit D1 to Exhibit D12 by the defendant witness. The details are in the body of the judgment. I also have the defendant's final written address here. It's captured in the judgment. The claimant's final written address is also captured in the judgment. I'll go then to also the defendant's reply on points of law is also captured. So I'll go now to the court's decision. The case before this court is an employment dispute commenced by the claimant challenging the termination of employment on the 11th of April 2022. The claimant alleges that termination was wrongful, tainted by personal animosity and victimization by the defendant's group HR director, Chief Kola Hassan. On the other hand, the defendant contends that the claimant's employment was lawfully terminated in accordance with the terms of a contract of employment, that she was accorded a fair hearing during an internal investigation into an anonymous joiner of Chief Kola Hassan. Exhibited that, and the final written addresses of learned counsel, this court is of the considered view that the issues raised by the parties can conveniently be distilled into the following for determination. One, whether this court lacks jurisdiction to determine this due to the non-joinder of Chief Hassan. Now, the defendant argues that because the claimant made specific personal tortious allegations against Chief Hassan, the group HR director, is a necessary party whose absence deprives the court of jurisdiction, relying on AMCON and Suru Worldwide Ventures. Citation was provided from the pleading and testimony. Parties are in agreement that the contract of employment exists between the claimant and the defendant, a corporate entity. The defendant company is a company duly incorporated and also a disclosed principal. In addition, the facts reveal that Chief Kola Hassan was a director with the defendant company as stated in paragraph 14 of the statement of fact. It is settled principle of agency that an agent is a person authorized by another person to act for or in his place. That is one entrusted with another person's business. See Upanya and Ayaya and Mobi Producing and Monopo. Citations all provided. Furthermore, the non-joiner of a party does not defeat an action. See Green versus Green. The relief sought in this suit, declarations of wrongful termination, payment of entitlement, and damages are directly solely against the corporate employer, not the director personally. It is the finding of this court that the Chief Kola Hassan acted at the material time as an agent of a disclosed principal. He is merely an employee and a director in the defendant company. He is not an indispensable party to the determination of the contract of service. The objection on non-joiner is dismissed, I so hold. Having found that this court possesses the required jurisdiction to determine this, I shall now proceed to consider a fundamental issue, whether the claimant's right to fair hearing was breached during the disciplinary process that culminated in the termination of the employment. The claimant contends that the fact-finding disciplinary panel constituted on 7th of April 2022 was by that the disciplinary proceedings culminating in the termination of employment were consequently null and void. In support of this contention, reliance was placed on Bangboye versus University of Ilorin citation provided. The law is, however, well settled that an administrative or a disciplinary panel established by an employer is not a court of law, but merely a domestic fact-finding body. Accordingly, the strict rules applicable to judicial proceedings do not apply to such panels. What the law requires is that the employee be afforded a fair opportunity to know the allegations against him or her and to respond before any disciplinary decision is taken. Section 36 of 1 of the Constitution requires that the party be given the opportunity to be heard before their rights are determined. In the context of employment disciplinary proceedings, Nigerian courts have held in cases like Adigboye versus UBA that the requirement of fair hearing is satisfied if the employee is informed of the allegations against them and given an opportunity to respond. This was this dictum in Baba, this is Nigerian Civil Aviation Training Center. This is often achieved through the query and response mechanism. In this case, the evidence shows that a multi-stage process. First, an invitation to a fact-finding committee, exhibit C3 and D7. Secondly, there was an actual hearing on April the 7th, 2022. And thirdly, a formal query was issued clearly stating out the allegations against her, exhibited in exhibit C9D, exhibit C4D9, followed by the claimant's response, exhibit C5D10. These facts are not in dispute. The legal standard for administrative or domestic panels is not the same as a criminal trial. The focus is on all the altering pattern. Here, the other side. This sequence of events demonstrate substantial compliance with the principles of all the altering patterns. Since the claimant admitted to receiving the query and providing a response, the threshold for fair hearing in an employment context appears to have been met, I so find. It is pertinent to note that the claimant's dissatisfaction with the committee's finding in Exhibit D8 does not equate to a denial of fair hearing. Fair hearing is concerned with the opportunity to be heard and not with whether the decision reached accords to the party's expectation. The law does not guarantee a favorable outcome. It guarantees only a fair opportunity to present one's case. The Court of Appeal in Agbarangbo versus Nakende 2000 citation provided reiterated that the essence of the rule of natural justice is that the party must be afforded an opportunity to present his case without let or hindrance. It is not in dispute that the claimant refused to cross-examine the witnesses at the fact-finding, not to answer particular questions or to decline to challenge the evidence presented before the committee cannot be converted into a complaint against the employer. An employee who has been afforded an opportunity to defend herself but elects not to fully utilize that opportunity cannot subsequently contest that she was denied fair hearing. The burden rests on the claimant to establish by credible evidence that she was denied the opportunity to present a defense or that the proceedings were tainted by actual bias or circumstances giving rise to real likelihood of bias, which is not the finding of this court. In the instant case, beyond the bare allegations contained in the pleading, no cogent evidence was placed before this court demonstrating that the committee was improperly constituted, that she was prevented from presenting a defense, or that the proceedings were conducted in a manner inconsistent with the rules of natural justice. The court took a close look at the composition of the fact-finding committee and noted that its membership was pulled from different affiliated companies of the defendant, as well as relevant labor unions and other members of staff who were suspected to have a hand in the alleged defamatory letter. They were all invited to appear before the committee. In the circumstances, this court is satisfied that the defendant complied with the procedural requirements of a domestic disciplinary process. The claimant was informed of the allegations against her. She appeared before the disciplinary panel. She received a formal query and submitted a written response. Consequently, the constitutional and common law requirements of fair hearing were duly observed. The mere fact that the committee ultimately reached findings adverse to the claimant does not render the proceedings biased or procedurally defective. I therefore hold that the claimant has failed to establish that a right to fair hearing was breached during the disciplinary proceeding. Now, on whether the claimant's employment was wrongfully terminated, the claimant argues that since the termination was triggered by allegations of misconduct, the anonymous defamatory letter, the defendant was bound to prove the misconduct beyond reasonable doubt. She relied on Shell Petroleum Development Company and Larawaju. It must be noted that the relationship between the claimant and the defendant is classified as a master-servant relationship governed strictly by the terms of the contract of service. According to the Supreme Court in UTC versus Peters, an employer has the inherent right to terminate an employee's appointment at any time and for any reason or even for no reason at all, provided the termination complies with the terms of the contract, especially where notice or payment in lieu of notice are satisfied. See Shenu versus Julius Berger. Citation also provided. While it is true that where an employer gives a reason for termination, the burden shifts to the employer to justify that reason. See Obani versus Union Bank. This principle applies strictly where the employment is summarily dismissed on those grounds. The employment is summarily dismissed on those grounds. In this case, the defendant did not dismiss the claimant. The defendant exercised his right under the contract Exhibit D2 and D5 to terminate the employment by issuing a letter of termination, Exhibit D4/D6, offering 1 month's basic salary in lieu of notice. The termination letter did not state misconduct as the basis for the termination. It stated that her services were no longer required. The offer of payment in lieu of notice brings the termination squarely within the terms of the contract of service. The evidence before the court demonstrates that the defendant issued a letter of termination, C6D4, and offered 1 month salary in lieu of notice, which aligns with the provisions of the employment contract C1D2. The claimant's allegations of bad faith, intimidation, or the unfounded nature of the anonymous letter allegations do not invalidate the termination that complies with the agreed notice period. Consequently, the defendant acted within its legal limits, legal rights, and the termination cannot be deemed wrongful under Nigerian labor law principles. The primary test for determining the wrongfulness of a termination is whether the procedure stipulated in the contract, such as the length of notice or payment in lieu, was followed. Where a contract provides for notice or payment in lieu, the employer satisfies the legal requirement by providing such payment. The claimant's allegations of negligence or lack of respect do not in themselves render a termination wrongful if the contractual terms were met. The court's role is not to compel an unwilling employer to retain an employee in a private contract of service. Since the defendant issued a termination letter, Exhibit D4, offering salary in lieu of notice, the burden shifts to the claimant to prove that this was a breach of a specific clause in Exhibit C1D2. Without proof that the notice period was insufficient or the payment was not tendered, the termination is generally held to be lawful, as the motive for termination is irrelevant in the master-servant relationship. The legal justification for this resolution is rooted in the principle that the court will not compel an employer to retain an employee in a private contract of service, where the Supreme Court reaffirmed that an employer can terminate an employee's services provided the procedure in the contract is followed. Also, in Section 11 of the Labour Act, it provides the statutory framework for termination by notice. Specifically, Section 11 sub 6 allows an employer to provide payment in lieu of notice, which the defendant did in this case. This provision applies here because the claimant's contract has been deemed to stipulate a notice period that the defendant satisfied through the offer of salary in lieu. Furthermore, Section 11 sub 9 of the Labour Act clarifies how such payments are calculated, ensuring the employee receives the monetary equivalent of their basic wages. Since the defendant complied with this requirement, the motive for the termination is legally irrelevant, as held in Obani and UBN, where the termination of the claimant's employment is hereby declared lawful and consistent with the governing contract of service. The claimant also is seeking 20 million naira as general damages and 200 million naira as specific damages. Under Nigerian civil procedures, special damages must be specifically pleaded and strictly proved. See AG Abia State and AG of the Federation, citation provided. The claimant failed to provide any particulars or let credible evidence to prove the loss of 200 million naira. General damages are only awarded upon the establishment of a civil wrong flowing from the wrong complained of. Having held that the termination of employment was lawful and complied with the contract of service, no claim for damages can arise. Accordingly, the claimant's claim for 20 million naira as compensation for trauma is unsupported by law, as no medical evidence or legal authority was presented to justify such an award. Where termination is lawful, no damages are recoverable. Where it is wrongful, the appropriate remedy is limited to salary in lieu of notice and other accrued contractual benefits. Damages in employment contract remain compensatory rather than punitive, except where proven workplace harassment or similar exceptional circumstances have caused quantifiable harm. The claimant's claim for general and special damages arising from the alleged wrongful termination, they have no foundation and are liable to be dismissed. In a master-servant employment relationship, the measure of damages is strictly limited to the salary the employee would have earned during the contractor notice period and any accrued entitlement. Since the defendant offered 1 month salary in lieu of notice, being the notice period stipulated in the contract, the claimant has already been offered the maximum remedy available in law. Claims for emotional distress, trauma, or loss of reputation are generally not recoverable in employment contract disputes unless supported by proof of an independent tort or exceptional circumstances which the claimant failed to establish. The courts have consistently held that the claimant must provide credible evidence to support every item of special damages. See Nigerian Security Printing and Minting PLC versus Umon citation also provided. This requires a high standard of proof, often involving receipts, vouchers, or detailed calculation of loss. In the present case, the claimant's request for 200 million naira appears as a round figure without a breakdown of how this sum was arrived at. In employment labor, specific damages usually cover unpaid salaries, allowances, or bonuses already earned but not paid. The claimant has not demonstrated how the termination of a role as an HR assistant resulted in a quantifiable loss of 200 million naira. Without specific pleading of the facts constituting this loss and strict proofs thereof, the claim fails the legal test for special damages. The court cannot engage in speculation or grant a windfall that is not supported by the evidence of actual financial loss incurred by the claimant. Consequently, the claim for specific damages is dismissed for want of proof. This court hereby finds that Relief 1 fails to the extent that the defendant validly terminated the claimant's employment in accordance with the terms of the contract. However, the second arm of Relief 1 succeeds to the extent that the claimant is entitled to 1 month salary in lieu of notice and should be paid immediately upon fulfilling the requirements for exit as required by the contract of employment. 2, the disciplinary investigation complied with the requirements of natural justice, therefore Relief 2 fails. The claimant has failed to discharge the burden of proof to establish that the termination was wrongful. Therefore, Relief 3 and 4 for an order directing the defendant to pay 20 million naira as general damages and 200 million naira for specific damages fails. Consequently, the first arm of Relief 1, 2, 3, and 4 are hereby dismissed in its entirety for lacking in merit, while the second arm of Relief 1 succeeds. Parties are to bear their respective costs. Judgment is entered accordingly. Failure to pay upon satisfaction of the exit requirement shall attract 10% interest. This is the judgment of the court.
We are most grateful, my Lord,
The court,
for
please.
the well-considered judgment. We pray that the Lord Almighty gives my Lord more wisdom. We are most grateful.
We are most grateful, my Lord.